the topmost level we have the NCDRC. And the appeals against the orders of NCDRC can be entertained by the Supreme Court. In my paper, I have studied that the High Court cannot bypass the statutory structure of appeals and not entertain appeals against the orders of SCDRC and NCDRC. Next, when we look at the grounds of appeals under CPA 2019, the appeals can be on the basis of both facts and law. Now, the new thing in Consumer Protection Act 2019, which was not there in CPA 1986, was there was an introduction of Section 51, which allowed for second appeals. So essentially, in CPA 1986, there could be only one level of appeal. Now there can be second appeals, which can be based upon substantial question of law from the SCDRC to the NCDRC. And next, if we look at the amount for appeals, so the party which has been directed by the relevant court to pay certain amount has to deposit 50% of this amount as a pre-deposit for appealing in the appellate body. Now the CPA 1986 gave another option to the party. They could also give or deposit a predetermined amount, which was 50,000 for the Supreme Court, 35,000 for the NCDRC, and 25,000 for the SCDRC. Now CPA 2019 removed these two options, and now the parties have only the option of paying 50% of the amount directed by the court for appeals. So essentially, why we have this amount is because the courts want to curb frivolous appeals, because that is something that would be inevitable if there is no sum for or pre-deposit for appeals. Next, when we look at the manner and form for appeals, the rules regarding the manner and form for appeals can be framed by the central government for the SCDRC and NCDRC. However, when we look at the deposition of the amount that I just talked about, the state government is empowered to make rules for the SCDRC. However, the central government still has the power to make the rules for NCDRC. Next, when we look at the alternate dispute resolution mechanisms in CPA 2019, we see that the settlements through mediation and conciliation cannot be appealed against. However, the orders of an arbitrator through arbitration can be appealed against in CPA 2019. And also, since CPA 2019 is a recent act, there have been a lot of appeals pending under the old act, which was the 1986 act. Then the obvious question that arises is that what would happen to these appeals which were pending under 1986 act? Would they continue under CPA 1986? Or would they continue under CPA 2019? So, for this, if we look at the General Clauses Act 1897, it says that the proceedings under a repealed act shall continue under a repealed act as if the repealing act, which is the 2019 act over here, did not exist, unless a contrary intention has been shown in CPA 2019. Now, since the CPA 2019 has explicit provision which says appeals under CPA 1986, thus the appeals which were being proceeded under CPA 1986 would continue under CPA 1986 and not be continued under CPA 2019. Interestingly, if we look at CPA 2019, it also enhanced the pecuniary jurisdiction of these three levels of consumer dispute resolution. So again, there was this issue as to whether due to change in pecuniary jurisdiction, would these appeals be transferred to as per the new jurisdiction, the new pecuniary jurisdiction of these consumer commissions. So interestingly, in Nina Anija versus Jayaprakash Associates, it was held that since Consumer Protection Act is a beneficial consumer legislation, and since the transfer of appeals would lead to undue hardship or uncertainty in consumer litigation, the transfer of appeals as per the pecuniary jurisdiction would be something not in the intent of the legislature. They would not want to have the consumers run from one forum to the another. So it was held that the pecuniary jurisdiction would be the old one and the appeals would continue as per it only. And lastly, if we look at the limitation period for appeals, the limitation period does not start when a mere order is pronounced by an open court starts when the order is duly signed and dated by the relevant court, and a free certified copy of the order is made available to both the parties. So lastly, despite this limitation period, the appellate bodies, in the interest of consumers, has the authority to condone this delay. They can condone small delays or bona fide delays. However, as a general practice, even though they have adopted a liberal approach in interest of consumer to condone small delays, they have refrained from condoning inordinate delays or delays which are guided by malafide intent. With this, I would like to conclude my presentation.
Thank you, Prachi. Now, I'm calling Rushi Batra for presentation.
Am I audible, Dr. So my topic is a very interesting topic, especially in today's times. That is how there is a conflict between special law and general law in relation to CPA 2019 in particular. And I say it's interesting because when I wrote my paper on this, the position of law was very ambiguous. But as recent as February 2022, the Supreme Court has now clarified the position of law, which we'll discuss as I go ahead with my presentation. So there are a few things I'd like to discuss today. Firstly, I'll discuss how the principle that special law overrides general law applies, but in particular relating to the CPA. I'll talk about how Section 100 of the CPA exists as a guiding light for courts to interpret the same. And thirdly, talk about how CPA is, in most cases, a general law and not a special law. And it's only in case of conflict that the debate even between special and general actually arises. And lastly, I'll talk about how res judicata applies, because when you have two laws, naturally you can't go to court against the same cause of action. So firstly, it's a well-established principle of law that special law overrides general law in most cases. For example, for the same would be, let's say, POCSO and the IPC. So while in POCSO there are certain crimes, certain accusations for which the presumption of innocence is actually turned right around its head. So the accused has to present that he is the one who is not committing the crime, which is obviously not what the IPC says. So POCSO being a special act would take precedence over the IPC, which is a general law. One thing to be kept in mind is it's only in cases of conflict that we even look at the special law versus general law distinction, because it's often assumed that the legislature is obviously aware of the laws that it itself passes. So naturally, only when there's conflict will the principles of harmonious construction take. Now, applying this to CBA in particular. Now, Section 100, small caveat here, so Section 100 of CBA 2019 is exactly the same as Section 3 of CBA 1986. So it's basically the numbering that has changed, but the section remains intact. So all cases I referred to are regarding the 1986 Act. So Section 100 basically says that all provisions of the CBA would be in addition to and not in derogation of any other law. So the legislative intent is absolutely clear that the legislature wants to provide additional remedies in addition to already existing remedies under the General Act, as being the case. There is an interesting case that the State Commission and the National Commission faced, and I'd like to share. This is the case of Cinco Textile versus Economic Transport Corporation, whereby there was a breach of contract and there was a subsequent loss to that contract. When the case went to the State Commission said that since it's a contractual case, this is outside our purview and therefore we will not be entertaining this case. The National Commission, in my view rightly so, overturned this judgment and said that the Section 100 is absolutely clear. You can't read into the law when the law is absolutely unambiguous. That is to say, that CPA provides remedies in addition to and not in derogation of any other law. Hence, while the ICA may apply in its own sphere, the consumer can. So basically, the only thing to be proved is that you have to be a consumer under Section 2 subclause 7. If you prove that, you can approach the Consumer Commission now. Then thirdly, which is the meat of the matter that I am discussing, is the special versus general debate in particular. So as I said, until very recently, the position was very convoluted. Convoluted why? Because in 2012, there was a judgment by the name of General Manager Telecom versus N. Krishnan and another. Note, this is the division bench judgment of the Supreme Court. The facts were very simple. The telephone connection was disconnected due to non-payment of bills. The dispute arose because Section 7B of the Telegraph Act says that any dispute that arises in the course of under the purview of the Telegraph Act will be resolved by arbitration only. So the question before the Supreme Court was whether CPA would apply in this case. And the Supreme Court, in unequivocal terms, said it will not apply because the Telegraph Act, being a special law, would override the CPA, which is in this case a general law, and therefore the only remedy available is to go to arbitration. This is the 2012 Division Bench Supreme Court judgment. Then in 2020, recently, there was a case under the Imperial Structure versus Anil Patni and another. Here also a similar case arose. Instead of the Telegraph Act, the conflict was between the RERA Act and the CPA. Here, interestingly, the Supreme Court said that the CPA would apply even though the RERA Act itself had a dispute redressal mechanism in place. And how many judges were there in this court, in this bench? 2 judges again. So we see both these cases are in direct conflict with each other. Both are division bench judgments of the Supreme Court. Now, luckily for us now, this judgment, another judgment has come as recent as 27th February, where a 3-judge bench headed by Justice Chandrachud had clarified that General Manager Telecom is actually bad law and you cannot follow that anymore. And an arbitral remedy or any other remedy for that matter would not vitiate the remedy present under the CPA. Okay, all you have to do is the consumer under Section 27 and you can approach the Consumer Commission for your dispute redressal. Lastly, I talk about how the principles of res judicata apply. So, when obviously there are 2 laws, the general law and a special law in case of a conflict, you can't go to both the civil court and the Consumer Commission at the same time for the same remedy. That's the broad basis of res judicata. So res judicata's principles are enunciated in the CPC. And CPC, if you read section 11 of the CPC, and where the principles of res judicata are enshrined, talks about courts. And we know for a fact that Consumer Commissions are not actually courts in the strictest sense. But this too has been clarified that for the purposes of res judicata, Consumer Commissions are to be considered as courts, and therefore the principles would apply. So as of today, the consumer has a prerogative. He can choose to go to whichever forum he wants to go to. He can choose to go to the civil court if you want to get a particular remedy. Usually consumers want to get compensation. They don't care about what's happening with the producer later. Usually that's the case. So for that you can obviously go to the Consumer Commission, which will be a more efficacious, faster, speedy redressal mechanism. So it's you pick your choice and then you stay. That's the process. So in conclusion, I'd just like to say there are 2 things we saw in this presentation. One is that res judicata applies, even though it's not a court in the strictest sense. And second, that the CPA is a social welfare legislation. So the usual position of law, that special law over general law, does not actually apply to CPA in the strictest sense. Because if it did, then there's a conflict between the RERA Act or the CPA or the Telegraph Act or the CPA, then the special law would take precedence. But that is not the case as we see, because CPA is obviously for consumers who are often at an unequal bargaining position and therefore should be provided with a more efficacious way of resolving the disputes. Thank you.
Thank you, Rushil. Now I request Siddharth Johar.
Hi. So, first of all, good morning to all the panelists and the students present here. So, my topic particularly restricts itself to the suo motu powers of the Central Consumer Protection Authority. I've taken this word particularly to understand the CCPA in particular in a much more nuanced manner through a specific example, that is the suo motu provision in Section 18. So, this particular paper essentially recognizes that there are certain concerns that the CCPA has to highlight. CCPA has to address, and it has certain tools and guidelines. I just give you a solution of the I, for one, take this route of understanding both these things through the words suo motu and establish the very legislative mandate of CCPA and flag certain concerns that the CCPA needs to take into consideration in its march forward towards proactive protection of consumers. So, first is the idea of suo motu inside, that is to extend the principles of social justice. So, what exactly is the purpose of suo motu powers? It is to extend the principles of social justice, to make the judicial process much more visible to those belonging to disadvantaged sections. And this sort of philosophy has travelled across executive and regulatory institutions to vest in them power essential for the fulfillment of the constitutionally sanctioned roles. For example, the National Green Tribunal, which has a role for protecting a clean and healthy environment. Similarly, if you look in case of consumer protection, you have certain rights imbued within the fundamental rights itself, and consumer protection organizations have to fulfill those roles. That is why suo motu power has to be provided. All the concern in this respect is flagged, which is the theory of separation of powers, which shall be considered later on in this. Now, it is also important to understand why we raise concerns with regards to this particular provision. What are the problems that CCPA particularly is trying to address? So first is the weak incentives to litigate for consumers. As we have talked about earlier as well, that there exists a huge backlog of cases and there are widespread vacancies in the commissions. So there is a certain inefficiency in the limitation of that. If you really look at Buddhist Mission Dental College versus Bhuvesh Khurana, it took the court 15 years to come to a decision. In such a scenario, consumers would not want to litigate and involve in the procedure in the first place. And secondly, there is no proactive monitoring of the complaints. Let's say take the example of misleading advertisements. Unless and until a complaint is filed, there is no way of knowing whether or not the advertisement was misleading. In such a scenario, any sort of high evolved form of exploitation, let's say even targeted advertisements, just go under the radar. Secondly, what institutions are as of now is that the National Consumer Protection Commission, National Consumer Disputes Commission, and the State Consumer Disputes Commission, both of which were not empowered under the COBRA 1986 and CPA 2019 to take up petitions through. Even though the state as a body was considered as a complainant, it did not actually launch any sort of petition on behalf of the consumers to that extent. So, simultaneously, on the other hand, even if you look at misleading advertisements, there is no particular authority or there is no particular institution that is deterring them from actually releasing all these advertisements. So we see two particular things that need to be addressed. One is evolved form of exploitation for which we need a highly specialized investigative body, and secondly, a need for a deterrent. That is what the CCPA essentially does. It provides you wide powers of inquiries and investigation to deter any sort of exploitation of the consumers. And in CCPA, I try to specifically restrict myself to three particular powers. One is this wide power per se. Secondly, to whom is this power actually accorded in the hierarchy of, let's say, district, state, and the national commission, national level. And third is the production of evidence in itself. So starting with the first, although the suo motu power has been granted to statutory bodies such as National Commission for Women and National Commission of Protection of Child Rights, the substantial difference is here that NCW and NCPCR does not have the power of actually injuncting any sort of a person who violates their guidelines. They do not have the power of adjudicating on the case. But CCPA does. It can enforce orders and upon non-compliance, file criminal action against the very people who violate consumer rights. Secondly, the Act itself gives powers to CCPA to adduce evidence, that is, gather evidence against those bodies. Let's say in the case of Cambridge Analytica, where Cambridge is gathering a form of information that is not known to consumers. What the CCP can do is, because it is constituted by experts, it can launch complaints on its own accord and therefore actually redress the complaints which go under the radar because consumers do not know about them. Right? Although this overlapping power between judicial and executive functions, something which which goes against Montes' theory of separation, we also have to recognize that this concept is of the past. And in today's time, we need hybrid models of power in order to enforce the powers in the very first place. Right? Secondly, if you look at suo motu, to whom is the suo motu power given to, it is only the central authority which is given to, not the district collector, not the regional authority. The reason simply being that there are 664 districts in India, and if you really give each and every one of them suo motu power, each and every district collector suo motu power, that might just come at a cost of accountability. How do we actually know that these people are getting these people are actually launching proper complaints, and how do we even ensure there is no sort of bias? Right? That is why these powers are only being given to the national authority. Although these concerns are equally prominent for the central authority, since it is at the national level, it has a high level scrutiny, and there exist terms within section 22 which are that complaints need to be in reasonable times, investigation needs to be in reasonable time. These terms per se make sure that CCPA does not go beyond its mandate. And the third point is with respect to production of evidence. As we earlier talked about, that in certain cases like Cambridge Analytica, it's not possible for consumers to get evidence. Therefore, CCPA, by constitution of a particular investigation wing that has additional director general, and all those particular people, they can effectively launch a complaint and gather information, which will also help all those from the marginalized sections who are not able to sustain the very cause of action to do that. Right? Although this particular difference I would like to flag here is that the opportunity of being heard does not actually come with a cross-examination of evidence for the people who against whom a complaint is lodged. The reason being that CCPA in its very essence is a proactive body. It does not want to make its process very sluggish, and therefore it does only let the adjudicatory model be restricted to opportunity of being heard and not cross-examination. So if you really compare all these entities, compare this entity with all those across, let's say, South Africa, USA, and all those countries, we see that this hybrid system of regulation is even in the USA, that Federal Trade Commission and Securities Exchange Commission, the Australian Competition Consumer Commission. Even in South Africa, the National Consumer of South Africa has this very hybrid model, indicating the very effectiveness and acceptability of this model. Therefore, this is something which is being propagated in India as well. So in conclusion, what I try to do is that analyze the very legislative mandate of CCPA through a simple word of suo motu in section 18 and try to flag what are the concerns that CCPA is trying to address, what exactly is should take into consideration in its march forward to protect consumer rights.